Hello, everyone, and welcome back to another episode on Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan, and today we will be diving into another very critical topic, a pressing issue, a very timely one as well. And before I tell you what the topic is and who our guest is going to be for our webinar today, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, X, and it's really amazing to have you. And good thing is that you can also participate by commenting wherever you're watching us. And yes, join us on YouTube, it will be great. But other than all these platforms, you can also join us on call. And for that, you will have to dial this phone number that's displayed on the screen above 425-436-6335, and the access code is 988-888. So join us, friends. And today's topic of discussion is how is ICE's crackdown impacting immigrant communities across the US? So yes, with all the news that's we are bombarded with right now, increased enforcement actions, deportation, workplace raids, school raids, so many in the list, right? And they're all making headlines. Many immigrants, both documented and undocumented, they're all facing new challenges, and families are also being separated. Businesses are struggling, students are struggling, and the fear is growing in so many communities out there. So to help us break down this very interesting and a very timely topic, especially on what's happening, what's going on, what rights individuals have, and what to expect moving forward here on. So, we have a very special guest who's going to join us once again, and he is Attorney Justin Rivera from Walston Immigration Litigation, a very experienced immigration attorney. So, please help me welcome him. Hi, Justin, and thank you so much for joining us today.
Hey, yeah, thanks for having me. It's always nice to be on, especially on a Friday. So thank you, I appreciate it.
Thank you. I'm looking forward. I know Fridays are supposed to be fun ones, especially that weekends are coming in, but our topic is such a serious one and,
Mhm.
all the dark times, I would say. So, what can folks out there expect from today's discussion?
So yeah, I think I will preface this by saying, WASDN LLC, particularly, we work with people on business immigration visas, work visas, things of that nature. So this is a little bit outside of my scope, a little bit outside my wheelhouse, but I think that after doing some research, I think I can provide at least an outline, a basic understanding of kind of what's going on right now, what is anticipated to occur, and kind of a little bit more about what this impact is going to be on not only people that are undocumented, but even people that are here in a legal status. So that'll hopefully I can shed light on that. There's a lot of great resources too that we'll try to highlight that are available to people as well.
Absolutely. I'm looking forward already. So, yes, we hear a lot of, things that you just shared before we started this webinar. We'll get into all that details as well. But I have some questions that I need to ask. And if we could start with, how has ICE's recent surge in deportation efforts, they have affected immigrant communities, particularly those without legal status? If you can
So
highlight those, it'd be very nice.
So yeah, I mean, anybody that's been watching the news has been aware of an increase in deportations and rates that is directly correlated to a change in administration. Where is that coming from? Basically, immigration officials are being given or have been given expanded enforcement discretion powers. So basically, they're being given a wider leash on what it is that they think qualifies someone as deportable in this circumstance.
Mhm.
Before, under the Biden administration, there was a prioritization, obviously, of certain individuals, probably people that weren't conforming with requirements for check-ins, things of that nature, violent individuals, stuff like that. Now it seems that there has been a wider scope, a wider net that has been cast as to who qualifies under this deportable statute, who they believe needs to be prioritized for deportation. A big thing that I was noticing when I was looking into it was that there are a lot of individuals who they take place in what's called routine check-ins. So these are people who, their immigration status is suspect or they're undocumented, and a part of what they do to work with the government in an attempt to find a remedy is they routinely have check-ins with, ICE officials or immigration officials. Apparently, according to a couple different individuals, some people in Florida and other places, apparently some of those people are starting to get detained and deported. Now, that was not a prior practice, mainly because these are people who are conforming to the government's needs and actually providing an avenue for them to be tracked if needed, or provide additional information or documentation. These people were not prioritized, but at the end of the day, they are very easy people to deport to show increased deportation numbers. And what that has done is created a fear. There are presently about 1.4 million people who currently have pending deportation orders in the US. All of those people are obviously going to be targeted. And that can be, basically a circumstance where someone, if they're caught, they're done. They're being deported. I think there's going to be a growing call to have people under expedited removal at a higher rate. And what that basically means, expedited removal is removal without the need to go before an immigration judge. It's literally, you're put in, you're questioned, you sign the forms, and you're done. They put you on the plane to get you out. I think that's going to probably increase. And I really feel bad for the people who have been attempting to kind of follow the rules through this check-in process. And it's frustrating for those people because they're kind of caught in a catch-22. If they go to the check-in, then they're seemingly risking being in a circumstance where they could be, detained and deported. But if they don't go, they can also be placed into the deportation pool for non-compliance. So all of this obviously creates fear. It creates a circumstance where people don't know what to do or how they're supposed to behave or act, or what steps they're supposed to take. And I think that's kind of the point. I think that the point is to create chaos. And I think right now there's definitely been a lot of chaos created.
It is getting chaotic already, and we can see, I mean, so many people are already almost getting deported. I mean, even Selena Gomez crying. Everybody is reacting to it.
I honestly can tell you personally, I have a story that I couldn't believe that I would have been talking about with people, but I'm going to tell you guys because it really happened to me. I got on a phone call on Wednesday with someone who called me because they're the younger brother of someone I know, someone I went to school with. And they called me because they needed to understand the I-485 adjustment process for people that marry a U.S. citizen. And the reason for that is because they had just found out that their girlfriend of 3 years, I believe, or 2.5, 3 years, had just been notified that their TPS status was going to expire. So this is, again, someone who's in the U.S. legally under temporary protected status. And this person's calling me frantically trying to figure it out, literally in the car driving to buy a wedding ring to expedite getting married so that he can ensure that this person can remain in the United States. That's the kind of chaos you're looking at right now. Going after people that are on parole, going after people that are on temporary protected status. It would very much shock me to think that those are the kinds of people that this administration's supporters wanted removed. And yet, here we are.
So, and that is just one case. There are so many stories out there. And
Yeah.
folks, if you want to share any of your stories as well, you can by commenting or by joining us on call. And it'll be really nice to have even Justin, tell us what we should do next. And with all these, deportations happening, Justin, maybe if you could give out some tips, as in what are some of the legal protections available to immigrants who are facing this right now, the threat
Right.
of deportation by ICE in this current climate.
So I would definitely say work with a lawyer that's more qualified than me in this regard. I would definitely say that. I can't sit here and say that I am qualified to handle this kind of exact case. But what I can do is at least provide general information and what people's rights are and what they can and can't do. So I want to say right off the bat, to kind of get rid of any rumor mills with the internet are always compounded. Legal permanent residents are not at risk in these circumstances. So that's a rumor that I saw when I was looking around on the internet. No, you're an LPR, you're fine. Um, People formerly on temporary protected status could be at risk, though. The idea promoted by the Trump administration was that people with criminal convictions, pending criminal cases, and people with final removal orders were going to be the prioritization. However, people with pending asylum or parole could honestly end up getting caught in this and getting arrested and eventually deported. Um, Specifically, humanitarian parole. I believe it was recently ended for Cubans and a couple of other different countries. So, what are kind of the rights of individuals? If it's a civil arrest, it's very complex. If it's a civil arrest, there's not necessarily a constitutional right to an attorney, but you do have a right to due process and a right to protection from self-incrimination. So what I'll explain by that is you have the right to remain silent, just like they tell you, on any Law and Order. You don't have to provide information. You don't have to give over anything. So in the event that you're detained, I would basically say don't talk, or express that you have the right to remain silent, and then secondly, express a right or a need to speak to your attorney. There's minutia there, but for the most part, you should have access to that counsel. I think another important thing to talk about is an ICE warrant. So an ICE warrant is an administrative warrant. And what that means is it does not allow the executing officer to demand entry into someone's home or their private space. However, a judicial warrant does. That is a warrant where they have gone and got it signed by a court to carry out an action. Typically, ICE is not going to go through the process of getting a judicial warrant because of how timely it is. So, if someone's in a situation where they're dealing with an ICE officer that is at their door knocking, you can say under the Fourth Amendment, you are required to show me a judicial warrant before I'm obligated to grant entry into my home. And then you can have them slide a copy of that warrant either under the door or through the window. You don't have to open the door. So warrants are typically going to be needed to go into sensitive areas. And sensitive areas are usually places like homes, schools, churches, doctors' offices, maybe courthouses. Now, under the Biden administration, most of those sensitive areas were explicitly non-targeted areas. And the reason for that is you don't want people that are here undocumented to be afraid to take their child to the doctor's office if their child is sick because they're afraid of being deported. So the courthouse was another one, similar thing. Maybe a child support case, for example. You don't want them to be afraid to go to the courthouse to appear for a child support hearing because then it hurts the system. Because now, the person can't pay child support, they can't put an order, paternity, any of that kind of stuff. What is the impact of that with the present administration? We're not sure. I mean, they rescinded Biden's guidance essentially. Now, they've been talking about saying, well, we're clearly not going to do that stuff, but we just don't think it needs to be, affirmed in writing that we're not going to do that stuff. So take it with a grain of salt. But this all kind of gets back to the fear avenue, like the notion that it's going to be difficult for people who are undocumented in particular to feel any level of comfort. It's scary for them. And I think that it's going to impact probably where they go, what they do, who they see, how they interact, because all of it's going to be suspect. They're going to be worried about the implications of the activity and whether or not ICE is going to be involved or even local law enforcement in some capacity. I think really for people just knowing that, and I'll talk about it a little bit more in further detail, but knowing, you don't have to talk. You can express that right. You don't have to say anything, and you can, express a desire for counsel would be my two big points.
Thank you so much. I mean, those were great tips, and folks out there, I hope you have noted that down. I mean, these are some of your rights. So I think it's always best to do more research and contact an expert, an attorney. They will be able to guide you best. And also, I mean, ICE, they're being joined forces by FBI, DEA, so many people out there, and Justin, what else do you have to say if you want to add more?
So for the local law enforcement, I think we were going to talk about it later, but I mean, we can talk about it now if you want. I wanted to do a little bit of diving into that and what role the local law
Sure.
enforcement is supposed to play in federal deportation actions. So there's this section of the INA that's called 287G. So under 287G, state and local law enforcement are permitted to question, arrest, and detain people for suspected immigration violations, and in very unique circumstances, place them into removal. But there is no power beyond that point. So
Mm.
what it kind of creates is, does that particular police unit, or like Harris County, for example, because I live in Texas, does Harris County want to cooperate with the federal government? Because if they do, they are not given additional resources, because they basically are told, you're going to operate within the grounds of what we have within our budget. But if you're a state funded entity and your main issue is to deter criminal activity, it's kind of hard to say, well, we're going to now fill up, 30 or 40% of our jails with issues related to immigration violations, and then also any time that's spent dealing with that is taken away from the amount of time that they can spend dealing with with criminal violations. So I think it really just is going to turn on where in the country that police, those officers are situated and how willing their offices are to comply. Now, in circumstances where they're carrying out issues for criminal activity, yeah, I think you're going to see some hand holding, because it makes sense. Hey, this person who has an immigration issue has also been convicted of a violent crime, or something of that nature. Then yeah, it makes sense for them to play ball. The idea of deputizing the state and local police to expressly look for immigration issues, I think, might be more suspect. I think time will tell on that, but it's probably not likely. That you're going to see a lot of participation, unless there's changes made in the law, in areas that are, maybe not predominantly blue, but maybe areas that have already large criminal issues. That police force is going to probably focus on that more so than help out with immigration issues. But we'll wait and see.
Yes, it's just getting more complicated. And from what we hear, people, or I mean, states who are not cooperating are also being said that they are going against Trump, and they are, facing more, what to say, um, like they are not compliant with what they need to follow.
Mm-hmm.
Well, thank you for that, and thank you for those tips, I would say. And I would also like to greet some of our, folks out there who have joined us with comments. Santosh, we have Kiran, AJ, and Mangu also. So, yes, I think we should take up Mangu's comments quickly, because I
Sure.
think it is related. I'm deeply concerned about reports indicated that many immigrants, particularly those from India, are being detained and deported without adequate access to legal representation. How can we ensure their rights are upheld during deportation proceedings?
So I think specifically in that circumstance, my experience is those are individuals who have entered through CBP, typically through an airport, and those individuals are inspected before they are admitted to the United States. When you are undergoing inspection, you are not basically granted admittance into the U.S. and subject to the U.S.'s protections and laws. So what that means is, if you are coming in, let's say through Chicago O'Hare Airport. I hate that airport, by the way. I want to tell everyone on this call, it's one of the worst airports in the entire United States. It's just garbage. The 2-hour waits at security. It's ridiculous. Anyway, sorry. If you're coming in through Chicago O'Hare and you're on, let's say, an H-1B visa, when you go through CBP, if they tag you after they look at your information, you can be placed in what's called secondary inspection, right? Secondary inspection is a place where they take you into a room or a waiting room and then have you called in, and then they basically question you about whatever it was that popped up in your record when they scanned your passport, or whatever information you said that they thought, that's weird, we're going to need to look into that. When that happens and you're in secondary, you do not have a right to counsel. you have not been admitted to the United States. There is no right to counsel. You can even have a G-28 from an attorney saying, this is the attorney that represents me. I'm coming into the US. I'm on a legal visa. Here's my G-28. The CBP officer is going to take that and say, that's fantastic. I don't care. They're going to throw it right in a trash can. So the thing about this is we have had people recently be put into secondary inspection for 4+ hours who have no immigration history of violation, no problems whatsoever. They're literally just picked out. And we've had their spouses call us and say, what do I do? How can I do anything? You can't do anything. That person is basically on their own. So what we have to start doing for people, and what our firm is doing for people, is we're coaching people beforehand. We're saying, look, what are the things that you could be asked? What are the ways that you should answer that comport with what's in the petition that you're using to apply? And how do you need to answer those questions? And in doing that, we're hopeful that coupled with the fact that these people, are highly educated and trained individuals, are able to get through the system. Now, the other thing that I will say about that, when you're going through CBP, once they put you in secondary, 9 times out of 10, they're pulling all of your electronics out. They're going through everything that you have. Because now that you're back there with them in secondary, they're going to say, even if the problem that we've identified is fine, we may as well take a look at everything else to see if there's something that we can figure out to say there's an issue to make this person removable. So I think that coaching is going to be necessary, and it's going to require employers working with employees or individuals who are coming in even on maybe F1s, talking to attorneys beforehand to make sure that they're ready to come through. Because I cannot express to you how bad an expedited removal order screws up somebody's immigration future. It's just the truth. I mean, they carry with them default, you're getting a 5-year ban. So that's a 5-year ban from the United States that you can only overcome with a waiver. And then if you actually end up having a ban that comes with a finding of fraud or misrepresentation, that's a permanent inadmissibility bar. So those are issues that are colossal. And I think that it's open season now with CBP. I think that they are very willing to pull people into secondary. And so, Mangu, to answer your question, they're not going to be entitled to representation. And I think unless they're coached properly at the outset, they could open themselves up for reasons to be deported, even if they're nonsensical.
Thank you so much, Justin, for taking that up for Mangu. And Mangu, thank you so much for joining us. But yes, I would like to say do subscribe to our channel, Immigration and Jobs Talk Show, where we come up with amazing discussions like these, webinars like these that could be very, very informative and helpful. So, yes, and I think we should quickly take up Rag's question as well at the same time. He says, hi, Nipa and Justin. Yes, have heard bad news about ORD, but which airports are more hospitable and how does SFO fare?
Not sure what SFO is. I'm not an air traffic controller. Is that San Francisco?
Me too, Rag. Tell us more about your question,
uh,
please. What do you really want to know?
I will tell you guys just off the top of my head from practicing history and what I've been dealing with. I don't like O'Hare. I'm not a fan. Yeah, it's San Fran. I have not heard bad things about San Francisco. I have not heard bad things about Seattle. That's another airport that's okay. I'm not a big fan of Dulles, which is in DC. I'm not a big fan of that one. I've seen a lot of people having issues with secondary there. And then those are kind of my big ones. The other one that I would caution people not to travel through ever is, I think it's the UAE, the Arab Emirates or something like that. The UAE airport, don't go through there. Like I've seen removal orders from UAE where the officers don't even know what the hell it is they're talking about or what they're basing their removal on. And yeah, eventually we can work on those cases and get those people back into the US. But you have to understand, once you're out, you're looking at best case scenario, probably half a year before you're getting back in. And that's if there's clear egregious error from what has happened to you. There's not clear egregious error, probably a year and a half, 2 years, maybe more. Some people are sitting out that entire expedited removal order. Yeah, that one, the one Rog just said. No, not a fan of CBP there. So yeah, I would say that there are bad airports. As that list expands, I can keep you guys updated. But for now, those are the ones that I don't like. The ones that I do generally are along the West Coast. Now that I'm starting to kind of think about it, I think the West Coast is usually more where I recommend people to travel through if it's optional. I've never had anybody have issues in like Denver or anything like that, but I'm not sure how many international flights you're getting there. But yeah, that's it. As I know more, I will let you guys know. There's definitely POEs also that I'm not a fan of, but I think that's really niche. That's only for people that are going to be traveling from Canada. So yeah, thanks for that question.
Thank you. Thank you so much. And I think we should also just read out AJ's comment. Please don't make the places foreign national come from seem like God-forsaken places that nobody in their right minds want to return to, because for the most part, that is not the case.
Okay. Look, man, you're entitled to your opinion, but at the end of the day, there are definitely people that try to come to the United States from places that are in significantly worse off, not only financial, but governmental circumstances than what is here. Um,
Yes.
it is
Thank you
what it
so
is.
much. Yeah.
Look,
Yes.
I
Yes.
understand that may be your opinion, but it may not be based in fact for everyone. Now, yeah, if somebody has to return to China, okay, they go back to China. The country at least has a semblance of a stable government, whatever your conditions against that government are. They at least have a stable government and an economy. There are plenty of places in South America that cannot say the same thing. And in fact, there are plenty of people who were just on temporary protective status who come from countries that can't say the same thing either. And at the end of the day, if your choices are between attempting to carve out a life in a place where you're unsafe and have no economic opportunities and trying to go to a place where you could have safety and economic opportunities, not only for yourself, but for the people you care about, a lot of people are going to pick that option. And to say
Yes.
that we're going to shut off that valve under the notion that, no, these people are coming from countries that are completely fine, I think is nonsense. And I'll go far enough to say, would you want to visit that place?
There you go, AJ. But thank you so much for participating. He's one of our, frequent
Yeah, no, I
viewers.
appreciate it.
Thank you.
Look. He's not completely wrong in
Yeah.
regards of all of it. At the end of the day, there are definitely people who are going to undergo removal and they're going back to completely stable countries. And yes, the world doesn't end for those people, but it does change the scope of their life. People who are immigrating typically are coming to the United States because they're seeking economic opportunity or something else that's drawing them in. That's the whole push pull of how immigration works. So yes, they'll go back to a country where they'll be fine, but it does change what they wanted to do, the scope of what they wanted to do with their life. And then that turns into a conversation about generally what you think about immigration itself rather than where the individual is coming from. But
Right.
all right.
Right.
Thank you though for the question. I appreciate it.
Thank you too, Justin, for taking that up. Such a sport you are. And, we should get back to our topic of discussion. And we are hearing so many raids happening already, affecting industries that depend on immigrant labor as well. So, what legal risks do employers face?
So I'll be honest. When I was looking into this, the biggest thing that I saw people complaining about is actually I-9 compliance issues. And I-9 compliance issues, basically, it's saying, when you hire somebody, they have to fill out an I-9 to show how they're in the country and able to work under authorization. If you violate I-9 compliance, you actually get dinged a set monetary amount for any violation related to the individual application. So if you have 45 employees and you have each one has 7 violations on it, however they drum it up, you're going to be looking at a circumstance where you're turning over thousands of dollars to the government, if not hundreds of thousands of dollars to the government. So that right there is a big thing. In terms of the workplace raids, I don't know if they've been at the level people were really thinking they were going to be. I think that there was kind of this presumption that day one you were going to see like just ICE everywhere, at every poultry factory or farm or any of these places where there's a presumption that undocumented workers are utilized. I'm not sure that's been seen at that big of a volume. I'm sure it's happened, but when it does happen, there are certain rights that individuals have. If you're a workplace owner, if you're the owner of a company, There's always the issue with the warrant. If it's an ICE warrant, it does not permit entry. It has to be a warrant from a judge. So until you set eyes on that, the individuals are not allowed to enter. You and your employees have the right to remain silent. You definitely have the right to counsel as the owner of that organization. I would recommend people be represented at all times at this point and have either a copy of a G28 on their phone or a copy of a G28 available in paper that they can hand over. And then have an opportunity to contact your counsel and, if possible, have your counsel present. Your employees have a right to remain silent. They have a right to remain silent, and they also should never, ever turn over documentation that is false. Never present anything that is false. Fake driver's license, social, whatever. Never turn anything over, and don't sign anything. I would recommend not signing anything until you've had an opportunity to have counsel review what's being signed. So if you are detained, be quiet, request a phone call, and request a copy of what's called the ICE National Detainee Handbook. So this is a document that has to be furbished when it's requested. Gives you an opportunity to look through it and know a little bit more about what your rights are. When you are that employer, request the ID of the individual ICE officer carrying out the warrant. Request a copy of the warrant, legal representation. Have a site manager assigned ahead of time who's going to know what to do during a raid. Don't talk without the lawyer present. And another thing about it is when you look at the warrant, you are allowed to contest anything that is beyond the scope of the warrant. So if the warrant is tailored to search in area X and the officers begin to divert off to area Y, that can be contested. And that's something that should be noted to your representation. So I would say to limit access to areas that are expressly mentioned within the purview of the warrant itself. And also, you do have a right to send all non-essential personnel home that are not required to speak with ICE. So you can clear out the area basically as well. But again, I would definitely say rule one, get representation ahead of time, speak with representation ahead of time, make a plan on what it is you're going to do, and then work from that. Let's not be reactive with this administration. Let's be proactive so that we're able to be prepared for when these things inevitably occur.
Absolutely. Very well put. And even this administration must have done just that. They have been planning this from a very long time and now putting everything out there for us.
No, absolutely. And, I honestly have to say, if you can say Trump, he sows chaos, he's a little bit, the freeze on grants and everything being what it was, going and being rescinded, nonsense, right? Have to give credit to how quickly this administration has begun implementing changes within immigration. It has been quick and it has been sweeping, not only for the undocumented, but for legal immigration as well. And so, yeah, they came in with a plan. They learned from the last time the administration was in a position of authority, and they are implementing those things very, very quickly.
Yes, very true. And, we still have so many questions to go. I would quickly like you to also highlight, how are FDNS site visits impacting H-1B employees as well? And, their employers in terms of compliance and even visa approvals.
So FDNS has been emboldened through changes in regulations, right? The H-1B modernization rule, which went into effect on the 17th, contained with it language that expressly codified the authority of FDNS. So now that it is no longer a voluntary process. It's a mandatory process, meaning that you have to play ball with FDNS. And if you don't, and they say non-compliance, then that's, their grounds or alleged grounds for opening the door for notices of intent to revoke for the H-1B. So what have we seen so far? I have not seen, as of now, a colossal uptick on the physical site visits, but those are very likely coming. What I have seen is an increase in the emails and phone calls being made to employees and employers requesting information and documentation. Now, those documentation requests, which were previously, maybe 8 or 10 things, and we would work and turn over maybe 6 because we think that they're actually related to the petition. Those have grown exponentially in scope. And we're getting to a point where I saw one the other day that was 34 different questions, and the officer alleged that there was a 24-hour response time to provide all of that. And a lot of these things are beyond the scope of the petition. They have nothing to do with the individual's H-1B, and they're more so a fishing expedition. They're an opportunity to look back on the entire immigration history of the individual with the hope of finding a violation of status. And now that the officers have the ability to say, well, if you don't comply, we're just going to refer this for notice of intent to deny or revoke. Employers are more on edge. And I think that when you're an employer and you're going into this and you're not aware of what it is that you do need to provide and what you don't need to provide, and you're handing over everything, USCIS is going to figure out that they can just keep hitting you over and over. And they're going to do so. So I think that, for FDNS, it's going to get more aggressive. I think that even though there hasn't been an increase in site visits, I think what we're seeing is the preamble to it. I think we're seeing the increase in calls and emails is a gathering step where they're going to accumulate documentation and then execute on-site visits, because I think they're going to go after people who are working at third-party sites. I think that they're going to go after people who are working from home. And I think their goal is going to be to take all of the information that's turned over to them, run it against the statements made by the people in person, if they're not represented by counsel and realize that they should shut up and hand over the G28. And then they're going to run everything against each other, and they're going to find something or try to find something that shows that there has been fraud or misrepresentation, which would allow them to send a notice of intent to revoke for the petition. And I think that's what they're going to do. And I think that's going to be a powerful tool for them too. I think it's going to be something that they're going to want to hire more people to do this, because it's a great way to scare the individuals that are working subject to non-immigrant work visas. And that's not even just the H-1s. I mean, the L-1s are people that I think could face being targeted, which are specialized knowledge and managers and executives from multinational companies. I think the F-1 program is probably going to be getting targeted in some capacity. So I think these are all things that are up they need to change basically how they're practicing now before it's too late and they end up into getting a revocation, because you get one and it really does open the door for them to just kind of hit you over and over again. And also, you have to remember what FDNS collects goes abroad to the consulates. And so not only are you dealing with issues with challenges potentially that you beat back with USCIS, could be grounds again for another issue when you go to apply for a visa abroad.
Right, right. And also, Justin, we've been hearing that, there's too much, a lot in the news, actually. Everything is definitely sparking more panic and everything. But do you think everything is true? There are also false rumors about ICE raids, which are really sparking all this panic everywhere across the United States. You want to say about that too?
Well, social media is both a benefit and a burden to society at large. I think that it does a lot of things well, and I think it does a lot of things poorly. And something it does really poorly is allow for the simplistic dissemination of false information. I think that, the need to verify things has kind of fallen off. I'll be anecdotal and just let you guys know I quit X. I left. I quit that. I quit Instagram. I just got to a point where I really couldn't handle it anymore. But
Me
unfortunately,
too.
it's kind of they're what is in our society now, and that information, that hole of false information, is what is constantly churned out to everyone. There are websites that are supposed to track statistical data in regards to deportations and raids and things like that. I would look at that information. I would use that as your barometer for making a decision about whether or not the information is true. That being said, just because there hasn't been this colossal raid for work sites doesn't mean that it's not precluded. It doesn't mean that it's not going to come in the future. My personal opinion from the research I've done and the conversations I've had is right now what they're doing is cherry picking. They're taking low-hanging fruit. They're trying to go after low-hanging fruit because they want those deportation numbers to be bumped immediately so they can show that they're carrying out their promises, right? A big goal of the Trump administration's first 100 days is all the promises that they're going to keep. So they'll do that because it'll be an opportunity for them to just grab people and kick them out. And that way they can say, look, we've got something done. It may be once that is done that then the workplace raids start. It's really just a matter of time to see how it is. From legal immigration, though, I will tell you guys, things has already begun to change. The consulates have changed. They've become more aggressive, more difficult. Very quickly, I'll note the F1 program is seeing challenges that we have never seen before. For example, optional practical training, which is called OPT. OPT, you are allowed to work without pay. You do have to be paid on STEM OPT, but for OPT, you can work on what's called an unpaid internship. So we are seeing people that are applying for STEM OPT, which is their 2-year extension of OPT, get RFEs and eventually denials. And basically, those denials are basically coming from this idea that under FLSA rules, the internship that they did that was unpaid should have been paid. And now this is really it's a very odd argument for the government to make, because first off, how is a USCIS officer able to make that determination? The officer is now becoming an expert in employment law and is now able to tell what positions merit pay and what positions don't merit pay. Additionally, these unpaid internships, your OPT can only be for a year. Whose jobs are being protected if you're going after people that are working on unpaid internships? Is there a bunch of U.S. citizens who feel like they're not getting their crack at unpaid internships that want them? I don't know. And that's
Yes,
what I
yes.
mean. It's literally just a tool to deny cases. And that's what their goal is. We just saw a notice of intent to deny come in literally before I got on this call, where they're saying that this person is not eligible for STEM OPT, which again, it's a 2-year extension of your OPT, lets you work for 2 more years. There are tons of requirements on it. You have to follow a specific training plan. It has to be approved by the school DSO, has to be paid, has to be in a degree related to your field. There is regulation and guidance over it. They're saying now that for some people, you went to a school and you went into a school that had a hybrid program. And the hybrid program allows you to take classes at home and at the school. They're saying that the school has failed to register this program with ICE as a hybrid program. And as a result of the school's failure to do this, you, the individual, have violated your status. And now your STEM OPT extension is denied. And
It's
again,
crazy.
it's great. What frustrates me so much about this is the goal is supposed to be to weed out fraud, right? It's to weed out people who are misusing or mistreating a system. How are these people doing it? They're not. It's just a new tool that they're going to try to use to deny people when they go to change status, when they go to apply for STEM OPT. And again, these are legal immigrants. These are people who paid money to go to schools in the U.S. and get an education here. People that we allege we want to retain because of their talent.
Exactly. And it would have made little sense if probably ICE would have sent a notice to the school instead, saying that you're not registered as a hybrid program or
Well,
something like
we've
that.
seen that they wouldn't bother to do that anyway. I mean, we've worked a bunch of cases recently where we had to get people's fraud findings removed because they worked at fraudulent employers. I mean, are they going after the employers? No, the employers just shut down. And then they go start another business or do something else. So yeah, it is this kind of ass backwards thought process by which you're saying we need to go after the kid that at the end of the day hasn't intentionally done anything wrong, rather than the entity or the institution that should know better or be responsible for what they've done.
Exactly.
Yeah.
And now, yeah, thank you so much, though, for that great example. And I think we still have a little bit more time, if you please, and we should take up our Facebook questions quickly. And I would say, Rag, AJ, thank you so much for coming back with more comments. I would appeal to you to join us on call if you can. Our phone number is 425-436-6335, and the access code is 988-888. All right, so let's take up this first one from our Facebook group. It's from an anonymous participant asking, hi, I have applied H1B through consultancy and I got RFE on November 2024. Yesterday, they are telling RFE document submitted, but in the site, it's still showing RFE status. Once RFE document submitted, the status will change, or is it the same as RFE status?
So usually it's going to change to like RFE received, and your case, your case is your clock has been resumed, your processing clock. So that's usually what's going to happen first. Now that being said, USCIS's online their website, the case status website, is kind of notorious for how slow it is and how long it takes to update. So I wouldn't be surprised if you just sent an RFE response if it hasn't been updated. If you know that it's been delivered and the RFE, like you have confirmation that it was delivered from the tracking, and you get to about a week or a week and a half and you still don't see an update, I would think about reaching out and maybe trying to contact the helpline. If it's premium, they're way nicer. If you just email premium processing, they're usually going to give you a heads up on what's going on. But of course, that's because you paid, or your company paid $2,805 more dollars for your case. So they're going to give you a little bit more detail. But usually the way it works is when you respond to an RFE, it's going to update and say RFE received and resumed processing. And then a couple of days will go by, or if you're in premium, a couple of days. If you're regular, Lord help you. But a couple of days will go by, and then it'll say RFE, case assigned with an officer, case assigned to an officer, case with an officer under review. That's just telling you that it's now on the desk of an officer so that they can look at the case and work on it. Does it mean your case will be approved within 24 hours, 48 hours, 72 hours? No. It just means that it's under active review. So after that happens, it's going to update. Usually it's going to update to either explaining that, the case was approved and an approval was emailed or will be sent to you, or additional information is needed. Another request for evidence has been issued, which don't be surprised if that's what you start seeing with the Trump administration. I'm just going to be very straight up with you. Anybody that submitted a first RFE and you didn't get your adjudication before Trump came into office, don't be shocked if a second RFE follows. That was very common under the last Trump administration, that you would get a first RFE on one issue and then you'd get a second RFE on 4 completely different unrelated issues. So don't be surprised if that happens. Just make sure you got a good attorney. But it'll update then, and then obviously worst case denial. Now, I want to tell everybody on this as an attorney that has practiced for going on 8 years, so we're all clear about something. If your case status updates to denied, your attorney does not know the reason for the denial until they get the denial notice. They are not clairvoyant. Now, yes, if the RFE is on specialty occupation only and the case is denied, specialty occupation. But they don't know why, because they don't get the adjudicator's reasoning until the denial notice is received by their office. And that can take a couple of days. So when your attorney tells you, knock on wood, I pray for you, no one gets denials. But if your attorney tells you, look, your case was denied, we have to wait and see the denial notice, it's not buying time. We genuinely don't know how to proceed until we see the notice. Do we think that there's an avenue that we can address the issue with premium processing? Do we think that we could file an appeal or a motion to reopen? How much time is left on your current non-immigrant status? And is this an opportunity where you can reapply? What is reapplying going to do versus appealing? All of those things have to be borne out by the language in the denial. So to answer your question, yes, it will update. Wait a week or two and then see what happens with it. And then if you're not in premium at this point, maybe think about upgrading to premium.
Yes, money talks, at least in this case. Premium processing is always, answered earlier. Let's go
Oh
on to
yeah.
our next. Yeah, thanks, Justin. To our next question, this is also from an anonymous participant. Hello, everyone. I have a question. With the modernization rule of H-1B visa effective from 17th January 2025, do we need to state the starting date on or after October 1st? Another question is my I-94 expiration date will be on June 15th, 2025. I will file I-129 on April 1st, 2025. So after filing, can I still stay in US until I-29 is approved? Or do I have to leave the US not later than 15th of June?
Okay, I'm going to do a lot of heavy lifting with this answer because I'm going to assume October 1st means you're talking about a quota case because quota, October 1st is the first date you can be eligible for an H-1B if your case is selected in that year's lottery. You can move the start date around now. That is now permissible. So you can move it back or forward. However, if your I-94 expires June 15, 2025, and you're filing on April 1st, I would probably say you're going to want to try to get work authorization as soon as possible. So yes, if it's a quota case, you can move back that start date. If your I-94, though, is expiring, I believe that would mean that you are in a different status because I believe F1 has DS as the status. So I'm going to handle that answer separately. If your I-94 expires June 15th, 2025, and you timely file an extension prior to that date, you are allowed to remain in the United States during the pendency of that application under what's called POSA bag. That's a period of stay authorized by the Attorney General. That POSA bag permits an individual to remain living in the United States and working subject to the conditions of that classification up to either the adjudication or I believe it's, please don't quote me, you may have to look it up, 280 days after the expiration of their status. So it's either 180 or 280. All that is to say, I would just file the extension. You can remain in the United States while the H-1B extension is pending, if that's what it is. And then I would probably check that statute to see how long you get. And if you start to get close to it, upgrade the case to premium.
All right, there you go. Thank you so much, Justin. Let's go on to our next one quickly, please. I have joined a new company, product company, and my I-797 was approved in September last year. I have had one stamping done for H-1B, still valid, but thinking of getting another H-1B stamping in May this year. With the new changes, is it harder to get stamping nowadays? I'm worried because I have an MBA and I work in software implementation. Are there major chances of getting refusals during stamping because of degree, or is it checked only during petition?
So usually when the consulate looks at an application, a visa application, the only thing that they're supposed to send back would be fraud or misrepresentation on the petition. So as long as the petition was approved and the documentation in the petition is valid and confirmable, there shouldn't be an issue that requires inquiry into eligibility. They should not technically be looking at if the position is a specialty occupation or if the beneficiary qualifies for the position. That's USCIS's job. So I would say the MBA isn't your concern here. I think what your concern is and should be for most people is the increased scrutiny at the consulates in general that have been placed on petitions by consular officers. That increased scrutiny, I think, is going to lead to an increase in 221Gs, and I think inevitably to an increase in visa refusals. So I would be a little cautious right now to go to the consulate, to be honest. I think in a perfect world, if you have the ability to wait a couple months and let the dust settle from this new adjudication and allow attorneys and companies to collect data so that they can start seeing what trends are, I think that's going to be your safest course of action. And that's regardless. I don't care if you have the squeakiest clean immigration record in the world. I don't care if you're a software developer and you're working for Apple and you have a degree in computer science. I would just say to anyone, just be careful. We're learning right now what to expect when people go abroad. I have an individual that I worked with at my former firm, and one of our client accounts had literally not received a denial, a blanket L visa denial in the preceding year or 2 years, I believe. They had already gotten two on this Monday. And that should be a little concerning because this is a massive multinational company. This is a corporation that you've seen advertisements for on television. It's a corporation that has a lot of power and money. They're getting visa refusals. So if these companies are getting visa refusals, what do you think the rest of the organizations are going to look like? What's it going to look like for them? So we have to wait and see. And that's why I say data is key. Once we figure out data, what are the trends? What are the consulates asking for? We can adjust and then make changes that are needed to make sure that people have the highest probability of an approval when they go in for their interview.
All right. So, Justin, at this moment, we actually have a caller, and he is John Santu, if I'm not mistaken.
Okay, I could
Quickly,
try. I'm very close to end on time. I'm sorry, but we're at
all
noon.
right. All right. John, if you could just quickly ask your question, please.
Yeah. Actually, I'm a non-citizen resident of this country. I've been here for at least 24 years now. I have filed my petition for marriage spouse. I had get abused by that. The spouse and I had separated. I asked her to let me file a divorce of that. She never did. I have end up in a fiancé, a person that I take and have make a life. She is a non-resident either, and we have two American citizen kids. But upon filing the marriage petition, I was they request more evidence. The immigration requests more evidence where the spouse have abused the power and said that she's not no longer doing the papers. And imagine we lived together for at least 9 years.
Oh.
What is my position here?
Wow, that's an impressive fact pattern. I'm not going to lie to you. What I would tell you, to be just completely blunt with you, is if you want to have a discussion that is very fact centric, I would ask you to send an email to my office, because I would have to really delve into that. I mean, the fact of the matter is if you and the other party are no longer married, then my assumption would be your I-485. It's kind of a null and void situation. I'm honestly surprised your former spouse, or I guess still current spouse, hasn't moved to withdraw the I-130. So that's already its own independent issue. And then getting into the other issues, I think that would require a pretty detailed discussion. So if you want to send me an email with your facts, I'd be happy to take a look at your case, because it sounds, complex and intriguing. So if you want to shoot me an email, it's my first name, Justin, at wasden.law, or you can send it to support@wasden.law, and they can filter you in. We'd be more than happy to take a look.
I know you kind I know you're kind of busy. I can take that information from your associate right here. I have a very fast question here, sir. I know you had to you had to go. The point is that I'm trying to get to is that I request a FOIA from immigration, and they never send that FOIA.
Okay. So you did a Freedom of Information Act, and you received confirmation of receipt of the FOIA?
Yeah, well, I did. I have contacted immigration consult, and we did send them for a FOIA, the FOIA, which means have the whole case that we dealt with.
Right. So usually how that works is you're going to get something back saying that your FOIA request has been received. It's going to be put in a particular category based on how complex or detailed it is, with a generalized timeline as to when you can anticipate receiving a response. Have you ever received any of that correspondence?
No.
Okay. So yeah, what I would probably do is follow up on that FOIA request then, just to make sure that it was properly submitted. Because the way it usually works is you submit the FOIA request, you get some level of acknowledgement, letting you know that it has been received, intaked, and assigned. And then you get a sort of timeline as to when you can anticipate getting your records returned to you. And then what they do is at the end of it, they send you basically a full breakdown of the documents, and usually what's a partial denial explanation. And they're going to say, look, we have either blocked this or X'd out certain parts of the document because of, and they'll say, national interest security, whatever have you, criminal investigation. But they have a litany of reasons why they can refuse certain parts of your FOIA. But the very first part of the whole FOIA request is you should be getting something back when you submit the request.
Yeah, because I have some of the documents that I have received from immigration, and when we went to that interview, I try to offer her if she does want our marriage to carry through. But imagine we have slept together for for at least 10 years, a whole decade. As wife, husband, and wife. But something went down the line, and she decided not to carry on with her marriage. And that's when they request more evidence of me as an individual.
All right. So, John, I think I would just suggest you best to, have a one-on-one consultation with maybe Justin. And first off, email him all the details, please. I hope that you have noted this down. Support@walston.law. And you can even call him on the number that is displayed on the screen. You can note it down, please. 844-592-7336. So I think we will have to, because your case is a little too complex and it cannot be solved right now. So it'll be best to contact him. Don't mind.
Okay. Now,
Uh, we will have to cut it short right now. So thank you so much for joining us
correct.
from Florida. All right. So thank you so much, Justin, for being so patient and for taking up all of our questions, and also, I mean, John Santu for joining us on call just now. We have
Yeah, no,
AJ, Rag, and so many folks out there. Thank you so much. But Justin,
thank you for
just
having me.
to
Yeah,
yeah.
last person, if you email me or whatever, that's fine, or set up a call. Look, they don't play around when it comes to marriage visa fraud. That's a pretty serious thing. So
Mhm.
I'm gonna tell you right now, like that's a pretty serious case, and I think it requires the attention that it needs. But anyway, I'm sorry for cutting you off.
No, I mean, I was just saying, yes, they will need to consult you because it's a very complex case. And maybe if you could just give us a few last words, to wrap up this session, this great discussion we had today.
Absolutely. Yeah, thank you for having me as always. I feel that this has been a fairly negative oriented conversation. Obviously, a lot of negative stuff. I will say this, our office had two recent beneficial outcomes in litigation that have assisted people with issues that they have had dealt with immigration. Their cases are being resolved presently, and we're hoping we can get them back, into the U.S. in the next, coming month or two. So that all that is to say this: there is still the courts are still being the courts. Like the courts are still doing what they can to follow the law right now. So that is always an avenue when everything else fails. There is litigation that's coming down the pipeline right now that is going to be challenging some of the modernization rule changes for the H-1B. So that's something that'll be coming up in the near future too. I'll maybe update you guys about it as it plays out. But yeah, all that being said, everybody, stay safe and have a fantastic weekend.
Thank you so much, Justin. You too. Have a fun Friday and a happy weekend ahead. I hope it gets positive by next week.
Me too. All right, have a good one. Bye.
You too. Bye. Folks out there, thank you so much for joining. I'm so sorry if we couldn't take up all your follow-up questions, but Rag, AJ, always good to see you. You guys are our frequent viewers, visitors. So keep commenting and thank you for sharing your opinions with us, AJ. Really great to know what you think as well and your thoughts. So keep sharing. And yes, don't forget to like, share, and subscribe to us. All of you folks out there, thank you for watching. Thank you for joining. And stay tuned on Immigration and Jobs Talk Show because we got more discussions coming up, especially today at 4 p.m. Eastern Time. We have Daily Immigration Dose, and I'm going to be back with my co-host Sam. And also, if you have to tell us more about your case or about yourself, please feel free to even contact me. And my phone number is 408-335-6444. You can even WhatsApp me in the same number. And you can email me. My email is nipa@staffingly.com. And yes, thank you once again for joining us. Stay tuned. Bye bye for now.